Hmm. What's live? One, two. All right. What? Yeah. Switch. When's the reading starting? Yeah, no, I'm just setting it, doing some setup. All right. All right, I'm doing this again. Welcome to part 3 of Alcohol Act. I don't know why I'm still doing this. All right. Section 106. Considering effects of issue or renewal of license on amenity and good order of locality. Fuck. Stay up. Stay. Yeah, yeah. Very good. Good order. Okay, okay. I read the title. Great. Good start. Why are 3 people watching this already? One. Well done. Great. Shocked you can read. Well, I can read. Well, informing of for the purpose. I haven't done this well. It's quite funny. Informing of for the purposes of Section 105(1)(h), an option on whether the amenity and good order of a locality would be likely to be reduced by more than a minor extent by the effects of the issue of a license. The licensing authority or a licensing committee must have regard to A. The following matters as they relate to the locality: current and possible future noise levels, current and possible future levels of nuisance and vandalism, the number of premises for which the licenses of the kind concerned are already held, and the extent to which the following purposes are compatible: the purposes for which land near the premises concerned is used, the purposes for which those premises will be used if the license is issued. Wow, how cool. Can I do that? I don't want free trial. Okay, there we go. That's better. Informing for the purposes of Section 131(b). Wow, okay. An opinion on whether the amenity and good order of a locality would be likely to be increased by more than a minor extent by the effects of a refusal to renew a license. The licensing authority or a licensing committee must have regard to the following matters as they relate to the locality: current and possible future noise levels, current and possible future levels of nuisance and vandalism. Yep. Next. 107. Authority or committee may refuse license even if application not opposed. Nice. You find this very educational. Great. That's what it's supposed to be. The licensing authority or licensing committee concerned may having regarding vandalism like throwing chairs through windows. Yep. Nice. Yep. The licensing authority or licensing committee concerned may, having regard to any matter stated in Section 105, refuse to issue a license even if no objection was filed against the application for it under Section 102 and no report was filed under Section 103 opposing that application. 108. License may be refused if contrary to local alcohol policy. The licensing authority or licensing committee concerned may refuse to issue a license if there is any relevant local alcohol policy, and in its opinion, the issue of the license or consequences of the issue. That is valid. Cool. Would be inconsistent with the policy. Haha. 109. Conditions may be imposed if required by local alcohol policy. The licensing authority or licensing committee concerned may issue a license subject to particular conditions if there is any relevant local alcohol policy and, in its opinion, the issuing of the license or the consequences of the issuing of the license without those conditions would be inconsistent with the policy. Okay, 109. How far are we gone? Yeah, there's still heaps to go. Oh god. I'll try and get up to like 150. Maybe. Depending on how long these sections are. 109. Just read. Oh, shit. Back to 109, I guess. Next section. Here we go. 110. Particular conditions on licenses and club licenses. The licensing authority or licensing committee concerned may issue an on-license or club license subject to conditions of any or all of the following kinds. Conditions prescribing steps to be taken by the licensee to ensure that the provisions of this Act relating to the sale or supply of alcohol to prohibited persons are observed. Conditions prescribing steps to be taken by the license to ensure that the provisions of this Act relating to management of the premises concerned are observed. Conditions for prescribing the people or kinds of person to whom alcohol may be sold or supplied. Conditions imposing one-way door restrictions. In the case of a club license or an on-license endorsed under Section 37, conditions requiring a manager to be on duty. Mm-hmm. The licensing authority or licensing committee concerned must ensure that every on-license and club license it issues is subject to conditions stating the days on which and the hours during which alcohol may be sold and supplied. If there are enforced regulations under this Act empowering the authority or committee to determine different levels of licensing fee prescribed by the regulations for premises of different kinds, stating the fees payable for the licensing of the premises concerned, and stating directly or by description a place or places on the premises at which drinking water is to be freely available to customers while your premises are open for business. In deciding the conditions under subsection 2A, that one, subject to which a license is to be issued, the licensing authority or licensing committee concerned may have regard to the site of the premises in relation to neighboring land use. Cool stream, yeah. Thanks. It is cool. I mean, I don't know. I'm just doing this. Subsection 1C is subject to Human Rights Act 1993. That one. 111. Imposition of one-way door restrictions by condition. A condition imposing one-way door restriction on a license may be created simply by issuing or renewing the license subject to a condition, stating that the license is subject to a one-way door restriction and stating that the day or days on which and the periods when the restriction applies, to the extent, if any, the elements of a one-way door restriction imposed on a license are more restrictive than the equivalent elements of an applicable one-way door restriction in a relevant local alcohol policy, the more restrictive elements prevail. Yep. Nice. 112. Compulsory conditions relating to display and promotion of alcohol in a single area in supermarkets and grocery stores. The purpose of this section and sections 113 and 114 is to limit, so far as is reasonably practicable, the exposure of shoppers in supermarkets and grocery stores to displays and promotions of alcohol and advertisements for alcohol. The licensing authority or licensing committee concerned must ensure that when it issues or renews an off-license for premises that are a supermarket or grocery store, it imposes on the license a condition describing one area within the premises that as a permitted area for display and promotion of alcohol. I reckon I should go put this on the TV at my job. That would be quite funny, but don't. Please don't. I mean, it would be funny though. One area. Here we go. On the renewal of an off-license for premises that are a supermarket or grocery store at any single area condition, any single area condition imposed when the license was issued or was last renewed expires. Subsection 3 is subject to section 1154. Yes. Okay. (113) Describing alcohol areas. The licensing authority or licensing committee concerned must have regard to section 112(1) when describing an alcohol area and when taking any other action under the section and when forming any opinion for the purposes of this section. An alcohol area must be described by means of a plan of the footprint of the premises concerned, or, in the case of premises on a more than one level, a plan of the footprint of the level on which the area is or is to be located, showing the proposed configuration and arrangement, or, in the case of renewal of license, the existing or proposed new configuration and arrangement of the premises or level, and the perimeter of the area. Nice. 3. The area may be so described that it is divided into 2 or 3 sub-areas, and in that case, the perimeter of each sub-area must be separately described, and the licensing authority or licensing committee concerned must designate one sub-area as the core area and one sub-area as the secondary area, and if the area divided is divided into 3 sub-areas, must designate one sub-area as the overflow area. All right. The perimeter of the area or any sub-area may pass through the proposed locations, or in the case of a renewal of the license, any proposed new locations, existing or proposed new locations of any display units. The perimeter of any area, the perimeter of the area or any sub-area may pass through the proposed locations. I just read that. The authority or committee must describe an alcohol area within the premises only if, in its opinion, it is a single area and the premises are or will be so configured and arranged that the area does not contain any part of or all of any area of the premises through which the most direct pedestrian route between any entrance to the premises and the main body of the premises passes, or any area of the premises through which the most direct pedestrian route between the main body of the premises and any general point of sales passes. So that's why, like in supermarkets, the beers and wine section is like in a corner or something, usually, what it looks like. For the purposes of this section and section 114, general point of sale means anything that is a checkout, till, or cash box where goods other than alcohol or alcohol and goods other than alcohol may be bought. or a device by which goods other than alcohol or alcohol and goods other than alcohol may be paid for without the involvement of any person other than the buyer, like a self-checkout. 114. Effective single area conditions. Every single area condition takes effect as a condition that the license of the premises concerned must ensure that no display or promotion of or advertisement of alcohol occurs on the premises at any place outside the alcohol area, and the premises are not configured or rearranged in a way whose effect, whether intentional or not, is that the alcohol area contains any area of the premises which the most direct or pedestrian route between any entrance to the premises and the main body of the premises passes, or any area of the premises through which the most direct pedestrian route between the main body of the premises and any general point of sale passes. If the alcohol area has not been so described that it is divided into 2 or 3 sub-areas, a single area condition also takes effect as a condition that the license of the premises concerned must ensure that no display or promotion of or advertisement of for a product that is not alcohol occurs on the premises at any place inside the alcohol area. Yeah. If the alcohol area has been so described that it is divided into 2 sub-areas, a single area condition also takes effect as a condition that the licensee of the premises concerned must ensure that things. No display or promotion of advertisement for a product that is not alcohol occurs on the premises of any place inside the sub-area designated as the core sub-area, and no display of promotion of or advertisement of a product that is not alcohol occurs on the premises at any place inside the sub-area designated as a secondary sub-area, unless it occurs at a time when no display or promotion or alcohol or advertisement for alcohol is occurring inside that sub-area. If the alcohol area has been so described that it is divided into 3 sub-areas, a single area condition also takes effect as a condition that the licensee for the premises concerned must ensure that no display or promotion of or advertisement for a product that is not alcohol occurs on the premises that at any place inside the sub-area designated as the core sub-area, and no display or promotion of or advertisement for a product that is not alcohol on the premises at any place inside the sub-area designated as the secondary sub-area, unless it occurs at a time when no display or promotion of or advertisement for alcohol is occurring inside that sub-area, and no display of or promotion of or advertisement for alcohol is occurring inside the sub-area designated as the overflow sub-area, and no display or promotion of or advertisement for tongue twister or a product that is not alcohol occurs on the premises at any place inside the sub-area designated as the overflow sub-area, unless it occurs at a time when no display or promotion of or advertisement for alcohol is occurring inside that sub-area. Far out. Nice. The effect of a single area condition set out in subsections 1 to 4 does not apply in relation to the display or promotion of or the advertisement for low alcohol and non-alcoholic beer, wine, or mead. any of that. Yep. Okay. For the purposes of this section, neither of the following is a promotion of alcohol. A sign consistent with other general signage in the supermarket or grocery store concerned, giving directions to or describing the location of an area where alcohol is available for purchase. Or two, a newspaper, magazine, or catalogue containing a promotion of or advertisement for alcohol and described means described under section 113, and designated means designated under section 1133b, and low alcohol or non-alcoholic beer, wine, or mead means that a product that is specified under section 58 1a to d, but that is not alcohol. Some tongue twisters in that section. Jeez. Next. 115. Application of single area conditions can be delayed for some renewals. In this section, new single area condition means a single area condition that is imposed on the renewal of an off license that is not subject to a single area condition, or that is imposed on the renewal of an off license that is subject to a single area condition, but is, in the opinion of the licensing authority or licensing committee concerned, materially different from that condition. When imposing a new single area condition, the licensing authority or licensing committee concerned may state a period not exceeding 18 months from the day on which the renewal concern takes effect, during which the condition will not apply. 1 moment. Yeah. The period stated, which must be no longer, in the opinion of the licensing authority or licensing committee concerned, is reasonably necessary to enable the licensee to configure the premises concerned so that the new single area condition can be complied with. When stating a period under subsection 2, the licensing authority or licensing committee concerned may state any other conditions, being conditions that the authority or committee thinks reasonable to apply while the new single area condition does not apply. Until the new single area condition applies, the other conditions take effect as conditions imposed under section 117 or 132. If the licensing authority or licensing committee concerned does not state a period under subsection 2 on renewing an off license subject to a new single area condition, the new condition applies as soon as the renewal takes effect. Yeah. 116. Particular discretionary conditions and other compulsory conditions off licenses. The licensing authority or licensing committee concerned may issue an off license subject to conditions of any or all of the following kinds. Conditions prescribing to be taken by the licensee to ensure that the provisions of this act relating to the sale of alcohol to prohibited persons are observed. B. Conditions prescribing the people or kinds of person to whom alcohol may be sold or supplied. In the case of premises where in the opinion of the authority or committee, the principal business is carried on is not the manufacture or sale of alcohol, conditions relating to the kind of or kinds of alcohol that may be sold or delivered on or from the premises. Can I do this? Okay. In deciding the conditions under subsection 2A, subject to which a license is to be issued, the licensing authority or licensing committee concerned may have regard to the site or of the premises in relation to neighboring land use. Subsection 1B is subject to the Human Rights Act 1993. What did I just read? 116. Yeah. 117. Other other discretionary conditions. The licensing authority or licensing committee concerned may issue any license subject to any reasonable conditions not inconsistent with this Act. So the generality of subsection 1 is not limited or affected by any other provision of this Act. One one eight. Different conditions may apply to different parts of premises. Any condition subject to which a license is issued may do either or both of the following: apply differently to different parts of the premises, and apply differently to the same part of the premises at different times, on different days, or both. 119. Restricted and supervised areas. The licensing authority or licensing committee concerned must do one of the things described in subsection 3 when issuing an on-license for a hotel or tavern. The licensing authority or licensing committee concerned may do one of the things described in subsection 3 when issuing a license of any kind for any premises other than a hotel or tavern. The things referred to in subsection 1 and 2 are: designate all of the premises, an area to which minors must not be admitted, or an area to which minors must not be admitted unless accompanied by a parent or guardian. Okay. Or designate a part or any two or more parts of the premises, an area to which minors must not be admitted, or designate a part or any two or more parts of the premises, an area to which minors must not be admitted unless accompanied by a parent or guardian. Or D, both. Designate a part or any or two or more parts of the premises that minors must not be admitted, and that again, unless accompanied by a parent or guardian. Variation of conditions. The holder of a license may at any time apply to the licensing committee to vary or cancel any condition of the license, whether the condition was or imposed by the licensing authority or the committee. The application must be made in the prescribed form and manner and be accompanied by any prescribed fee. Yeah. The applicant must comply with the notification requirements in section 101. And any person may object to the grant of the application, whether as an individual or as a representative of a group or an organization. However, a trade competitor may object to the grant only if the trade competitor is directly affected by the grant in a way that does not relate to trade competition or the effects of the trade competition, and a person may not object to the grant if the person receives or is likely to receive direct or indirect help from a trade competitor to object to the grant. Every objection must comply with the requirements set out in Section 102, 2 to 5. Sections 103 and 104, with any necessary modifications, apply to applicants under this section. In considering the application, the licensing authority or licensing committee concerned must have regard to any relevant matter that is specified in Section 105. In deciding whether or not to not or what to extent to vary any conditions imposed on a license, the licensing authority or licensing committee must have a regard to any inconsistency between the conditions as proposed to be varied and any relevant local alcohols policy. Yeah. There we go. Duration 121. License expires when new license issued for same premises. A license of any kind expires when another license of the same kind is issued for the premises concerned. Expiry or renewal of licenses. In this section, end of its currency. For a license that has been renewed before means the close of the last day of the period for which it was last renewed. For a license that has not been renewed before means the close of the last day 12 months after the day it was issued. Wait a moment. Cool. End of the prospective renewal period. For a license that has been renewed before, it means the close of the day 3 years after the last day of the period for which it was last renewed. And B, for a license that has not been renewed before, means the close of the day 4 years after the day it was last issued. If no application to renew a license has been made before the end of its currency, it expires at the end of its currency. A license expires as provided in subsection 4 or 5 or continues in force as provided in subsection 6 if an application to renew it has been made before the end of its currency, but it has not been renewed before the end of its currency. If a decision to refuse or renew the license has been made before the end of the prospective renewal period, it expires on the day stated under section 1352. If no decision on the application to renew the license has been made before the end of the prospective renewal period, it expires at the end of the prospective renewal period. If a decision to renew the license has been made before the end of the prospective renewal period, its renewal takes effect for the period stated under section 1351 at the end of its currency. 123 application of section 122. Section 122 applies to a license only if it has not already expired under another provision of this Act and is subject to A, the requirements of this Act relating to the payment of fees and the provision of this Act relating to the suspension, cancellation, and surrender of licenses. 124. Application for renewal lapses if license expires. An application for the renewal of a license lapses when the license expires. 125. Renewals. Restriction on renewal of off-licenses. The licensing authority or licensing committee concerned must not renew an off-license unless the premises are premises for which, by virtue of Section 32, 34, or 35, an off-license can be issued, or the license has continuously been held by a club since before the commencement of Section 28. 126. Renewal of license held by an auctioneer or caterer. The licensing authority or licensing committee concerned must not renew a license endorsed under Section 38 or 39 unless the licensee continues to qualify for the endorsement of the license. 127. The application for renewal of license. The holder of a license may apply in accordance with this section to renew the license. Every application for renewal must be filed with the licensing committee with which the application for the license was filed, and must be made no longer than 20 working days before the no later than 20 working days before the expiry of the license, or by such later date not being later than the date of expiry of the license as the licensing committee may allow, and must be made in the prescribed form and manner, and must contain the prescribed particulars, and if it relates to any premises must be accompanied by a statement by the applicant that the owner of the license of the building must be in which the premises are situated and provides and maintains an evacuation scheme as required by Section 76 of the Fire and Emergency New Zealand Act 2017, or because of the building's current use, its owner is not required to provide and maintain such a scheme, or because of the nature of the building, its owner is exempt from the requirement to provide and maintain such a scheme and must be accompanied by the prescribed fee. 3. The applicant must comply with the notification requirements set out in Section 101, but public notice of the application must be given within 10 working days after the filing of the application, not 20 working days. Objections to renewal. Any person may object to an application for the renewal of a license, whether as an individual or as a representative of a group or an organization. However, a trade competitor may object to an application only if the trade competitor is directly affected by the application in a way that does not relate to trade competition or the effects of trade competition, and a person may not object to an application if the person receives or is likely to receive direct or indirect help from a trade competitor to object to the application. Every objection must be in writing and must be filed with the licensing committee within 25 working days after the first publication of the public notice of the making of the application. No objection may be made in relation to any matter other than those stated in Section 131. The Secretary must send a copy of every objection to the applicant. 1 to 9. Police, medical officer of health, and inspector must inquire into application. The obligations of the Secretary, Police, Medical Officer of Health, and Inspector set out in Section 103 apply to an application for a renewal of a license. 130. Who decides an application for renewal? A licensing committee may decide any application for renewal of a license. With the leave of the chairperson of the licensing authority, a licensing committee may refer any application for renewal of a license to the authority for decision. The licensing committee must forward the complete file relating to the application to the licensing authority. The complete file means the application and any papers filed in support of the application, and a copy of the public notice of the application and a statement of the dates of publication of the notice, and any objection and any papers filed in support of the objection, and any reports made under Section 103. Criteria for renewal. In deciding whether to renew a license, the licensing authority or licensing committee concerned must have regard to the following matters. The matters set out in paragraphs A to G, J and K of Section 105. 1. Whether, in its opinion, the amenity and good order of the locality would likely to be increased by more than a minor extent by the effects of a refusal to renew the license. And any matters dealt with, any report from the police, an inspector, or a medical officer of health may, by virtue of Section 129, the manner in which the applicant has sold, or as the case may be, sold and supplied, displayed, advertised, or promoted alcohol. The authority or committee must not take into account any prejudicial effect that the renewal of the license may have on the business conducted pursuant to any other license. 132. Imposition of conditions on renewal. When renewing a license of any kind, the licensing authority or licensing committee concerned may impose any conditions subject to which it may issue a license of that kind and must impose any conditions subject to which it may issue a license of that kind and may, whether consequentially or not, vary or cancel any conditions applying to the license before its renewal, whether they are conditions subject to which the license was issued or conditions imposed on some earlier renewal. A condition imposed has the same effect as it would if it were a condition subject to which the license was issued, and in particular, a failure or refusal to comply with something. Where was I up to? Or yeah. Here. Whether it has the same effect and may result in the same consequences as a failure or refusal to comply with a condition subject to which the license was issued, and may be varied under Section 120 as if it were a condition to subject to which the license was renewed. Subsection 1 applies to all renewals of licenses and whether they were issued under this Act or a former licensing act. Okay. We're up to 1, 2, 3. I'm gonna do a decent amount of it. Bloody sick. Matters that relate to decisions to renew licenses. Renewal of licenses where relevant local alcohol policy exists. Mm-hmm. A licensing committee or licensing authority may decline to renew a license if it considers that renewing the license would be inconsistent with any policy set out in the relevant local alcohol policy relating to a matter specified in section 77 1A to D. Impose conditions on any license that it renews if it considers that the renewal of the license or the consequences of the renewal of the license without those conditions would be inconsistent with the relevant local alcohol policy. Okay. 1 through 4. Licensing committee may decide a certain application on papers. The licensing committee may decide an application for renewal of a license on the papers if there are no reports opposing or renewal or objections. Okay. 1 through 5. Decision on renewal. After considering an application for the renewal of a license, the licensing authority or the licensing committee concerned may, subject to section 133, renew the license for a period of not more than 3 years on the conditions presently attaching to it or any different conditions relating to any other matter that the authority or committee thinks fit. If the licensing authority or committee refuses to renew the license, it must state that the day on which the license expires and that the day must be no later than 3 months after the date of its decision. Temporary authorities. On license and off licenses. A licensing committee on the application of a person who appears to the committee to have any right, title, estate, or interest in any premises or any business conducted in any premises for which an on-license or off-license is in force, make an order authorizing authorizing the applicant or some suitable person nominated by the applicant to carry on the sale and supply of alcohol for a period not exceeding 3 months, stated in the order. The application must be made in the prescribed form and manner. What's the time? Okay. And be accompanied by the prescribed fee. The committee may hear and determine the application without notice or direct that the notice of the application and the time and place fixed for any hearing be served on any persons and in any manner the committee specifies. On making an order, the committee or the chair, as the case may be, must impose any conditions that this act requires an on-license or off-license, as the case requires, to be issued subject to and may impose that this act and Act enables an on-license or off-license, as the case requires, to be issued subject to and may impose any other reasonable conditions it thinks fit. Despite subsection 1, if the application is uncontested, the chair of the committee may make an order instead of the committee. The person authorized by the order has, for the purposes of this act, the same duties, obligations, and liabilities as the holder of the on-license or off-license concerned. For the purposes of this section, if the chair of the committee makes an order instead of the committee to a reference to the committee in any other relevant provision of this act is to be treated as a reference to the chair. 7. Subpart 4. Great. Okay. Licensing process for special licenses. Applications for special licenses. Filing of applications. An application for a special license must be filed at least 20 working days before the day on which the event concerned begins. With a licensing committee for the district in which the premises concerned are situated, if it is an application for a premises, for a license for premises that are not a conveyance, with a licensing committee for the district in which the applicant's principal place of business in New Zealand is situated, if it's an application for a license for a conveyance. The licensing committee may consider an application for a special license filed less than 20 working days before the day on which the event concerned begins, if satisfied that the need for a special license could not reasonably have been foreseen earlier. If, under subsection 2, the licensing committee decides to consider an application for a special license filed less than 20 working days before the day on which the event concerned begins, it must, after consulting the police, medical officer of health, fix a period of less than 15 working days after receiving a copy of the application within which reports from the police or medical officer of health must be received, and it must notify the police, an inspector, and the medical officer of health of the period fixed when sending copies of the application under section 1411. If the licensing committee fixes under subsection 3 a period of less than 15 working days, the references in section 141 to 15 working days must, in relation to any report of the application concerned, must be read as a reference to the period fixed. 138. Form of application. An application for a special license must be made in the name of the person who will hold it if the application is granted, and must state whether the applicant wishes the license to be designated as an on-site special license, an off-site special license, or both, and must be made in the prescribed form and manner, and must contain the prescribed particulars, and must be accompanied by the prescribed fee. Notification requirements. An applicant for a special license must comply with any applicable notification requirements prescribed by the regulations made under this Act, and if required to do so, may, by the Secretary of the Licensing Committee concerned, must, within 10 working days after filing the application, ensure that the notice of the application in the prescribed form is attached in a conspicuous place or on adjacent to the site to which the application relates. 140. Object. What the hell? Um, 140. I'm going to find 140 again. Objections to applications. Any person may object to the to the grant of a special license, whether as an individual or representative of a group or an organization, but only if the secretary of the licensing committee concerned has, under Section 139B, required that the applicant to give notice of the application for the grant. However, a trade competitor, this is the same thing as earlier, but for a special license, may object to the grant under subsection 1 only if the trade competitor is directly affected by the grant in a way that does not relate to trade competition or the effects of trade competition, and a person may not object under the subsection 1 if the person receives or is likely to receive direct or indirect help from a trade competitor to object to the grant. An objection must be in writing and filed with the licensing committee within any period the secretary requires the applicant as complied with the requirement under Section 139B. No objection may be made in relation to a matter other than a matter specified in Section 142. The secretary must give a copy of every application to the applicant. 141. Inquiry into applications by police, inspector, and medical officer of health. On receiving an application, 1 moment. Is this still in special licenses? It is still in special licenses. Inquiry into applications by police, inspector, and medical officer of health. On receiving an application for a special license, the secretary of the licensing committee concerned must send a copy of it and of each document filed with it to the constable in charge of the police station nearest to the premises for which the license is sought, or the secretary's office where the license is sought for a conveyance, and an inspector and the medical officer of health in whose district the premises are situated, or in whose district the applicant's principal place of business in New Zealand is situated where the license is sought for a conveyance. The inspector must inquire into and file with the licensing committee a report on this application. The police must inquire into this application, and if they have any matters in opposition to it, must file with the licensing committee a report on it within 15 working days after receiving the copy of it. The medical officer of health may inquire into the application, and if he or she has any matters in the opposition to it, may file with the license committee a report within 15 working days after receiving the copy of it. The licensing committee may assume that if no report is received from the police or medical officer of health within the 15 working days after the police or medical officer of health received the copy of the application, the police or medical officer of the health does not oppose the application. The secretary must send to the applicant a copy of any report filed with the licensing committee under this section. This section is subject to Section 1374. 142. Criteria for issue of special licenses. In deciding something. Yeah. In deciding whether to issue a special license, the licensing committee concerned must have regard to the following matters. The object of this act, the nature or of the particular event for which the license is sought, and in particular, whether the applicant is engaged on or proposes at the event to engage in the sale of goods other than alcohol, low alcohol refreshments, non-alcoholic refreshments, and food. If so, which goods, and whether the applicant is engaged in or proposes at the event to engage in the provision of services other than those directly related to the sale of alcohol, low alcohol refreshments, and non-alcoholic refreshments, and food, and if so, which services. The sustainability of the applicant, the suitability of the applicant, any relevant local alcohol policy, whether it's in its opinion the amenity and good order of the locality would likely be reduced by more than a minor extent by the effects of the issue of the license, the days on which the hours during which the applicant proposes to sell alcohol, the design and layout of the premises concerned, whether the applicant has appropriate systems, staff, and training to comply with the law, any areas of the premises that the applicant proposes should be designated as restricted areas or supervised areas, any steps the applicant proposes to take to ensure that the requirement of this act in relation to the sale and supply of alcohol to prohibited persons are observed, the applicant's proposals relating to the sale and supply of non-alcoholic drinks and food, and the sale and supply of low alcohol drinks, and the provision of help with or information about the alternative forms of transport from the premises. Any matters dealt with within any report from the police, the medical officer of health, or any inspector made under Section 141. The licensing committee must not take into account any prejudicial effects that the issue of the special license may have on the business conducted pursuant to any other license. 143. Additional requirements for large-scale events. If in the opinion of the licensing committee, concerned an application for a special license relates to a large-scale event, if the committee may do any or all of the following: require the applicant to provide the committee with a management plan describing how the applicant proposes to deal with matters such as security monitoring, interaction with local residents, and public health concerns, and require the applicant to provide the committee with a certificate by the territorial authority that the proposed use of the premises meets the requirements of the Resource Management Act 1991 and of the Building Code. Require the applicant to liaise with the police and the territorial authority on planning for the event. In deciding whether to issue a special license, the licensing committee concerned may have regard to the following matters in addition to the matters stated in Section 1421. Whether and how well the applicant has complied with any requirement under subsection 1A, and whether and how well the applicant has complied with any requirement under Section 1C, and whether the police and territorial authority are satisfied with any liaison that has taken place. 144. Licensing committee may refuse special license of own motion. Oh, I didn't realize you're on. um, Hello. Go to YouTube. Oh, right. Yeah, fair, fair. I just hear you in my ears out of nowhere because it's a live stream. It doesn't give the call sound on Discord. Yeah, yeah. Anyway, I'm gonna keep yapping. 144. Licensing committee may refuse special license of own motion. Oh, by the way, your voice can't be heard. Do you want your voice to be heard? Okay, I'll leave it out. I'm pretty sure your voice can't be heard. Try say something again. Oh yeah, I've got desktop audio. It's only picking up my microphone, so yeah, yeah. Anyway, the licensing committee consider. Now that I know someone's actually listening, it's crazy. I can't keep a straight face. God damn it! Thanks. Um, the licensing committee concerned may, having regard to any matter stated in section 142, refuse that to issue a special license, even if no objection was filed against the application for it under section 140 and no report was filed under section 141 opposing the application. 145. Shut up. Goofy our laws, thanks. Alright, alright. 145. This is section 145. Special license may be refused if contrary to local alcohol policy. Not the trumpet. The licensing committee concerned may refuse a special license if there is any relevant local alcohol policy and, in its opinion, the issue of the license or the consequences of the issue of the license would be inconsistent with the policy. 146. Conditions may be imposed if required by local alcohol policy. The licensing committee concerned may issue a special license subject to particular conditions if there is any relevant local alcohol policy and, in its opinion, the granting of the license or consequences of granting the license without those conditions would be inconsistent with the policy. 147. The particular discretionary conditions and compulsory conditions, special licenses. The licensing committee concerned may issue a special license subject to conditions or of any or all of the following kinds. conditions prescribing steps to be taken. Thingy, blah 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 blah. Steps to be taken by the licensee to ensure that the provisions of this act relating to the sale of alcohol to prohibited persons are observed. Conditions prescribing the people or kinds of person to whom alcohol may be sold or supplied. In the case of premises where, in the opinion of the committee, the principal business carried on is not the manufacture or sale of alcohol, conditions relating to the kind or kinds of alcohol that may be sold or delivered on or from the premises. Conditions requiring the provision of food for consumption on the premises concerned. Conditions requiring low alcoholic beverages to be supplied, available for sale and supply. Conditions requiring non-alcoholic beverages to be available for sale and supply. Conditions requiring assistance with or information about the alternative forms of transport from the premises concerned to be available. Conditions requiring the exclusion of the public from the premises concerned. Conditions requiring alcohol to be sold and supplied on the premises concerned only in containers of certain descriptions, or requiring alcohol not to be sold and supplied on the premises concerned in containers of certain descriptions. Conditions requiring the filing of returns relating to alcohol sold pursuant to the license. Any conditions of a kind subject to which any license may be issued under Section 110 or 116. Any reasonable conditions that, in the committee's opinion, are not inconsistent with this Act. The licensing committee concerned may do one of the things described in Section 1193 when issuing a special license. Shut up. God damn it. That was loud. Yeah. Alright. Where was I up to? Any reasonable conditions that in the committee's... Okay, I read that bit. The licensing committee concerned may do one of the things described in Section 119.3 when issuing a special license for any purposes. The licensing committee concerned must ensure that every special license it issues is issued subject to conditions stating the days on which and the hours during which alcohol may be sold or delivered, and stating directly or by description a place or places on the premises at which drinking water is to be freely available to customers while the event or any of the events described in it is taking place. In deciding the conditions under Section 3A, subject to a license is to be issued, the licensing committee concerned may have regard to the site of the premises in relation to neighbouring land use. Subsection 1B is subject to the Human Rights Act 1993. Section 148. Different conditions may apply in certain cases. A special license may be issued to conditions applying differently to different parts of the premises concerned. A special license designated as both an on-site special license and an off-site special license may be issued subject to conditions applying differently to the activities to be undertaken by virtue of the different designations. 149. Duration of special licenses. A special license is enforced as follows. If issued for a single event, it is enforced on the day or days on which the event occurs. If issued for a series of events, it is in force for the lesser of the following periods: the period during which the events occur, and the 12 months after its issue. If issued to the holder of an on-license or a club license for the premises for which the on-license or club license is held, it is in force for a period of not more than 12 months after its issue, stated by the licensing committee concerned when issuing it, or if no period is stated, for 12 months after its issue. If a single event or any part of a single event for which a special license is issued is postponed to some other day, the license is in force on the day on which the event or part takes place. 150. Display of special licenses. On issuing a special license, the licensing committee concerned with may give any directions relating to the display of special license of the special license and of the conditions subject to which it is issued, the committee thinks necessary or desirable. The holder of a special license must ensure that all directions under subsection 1 are complied with. Other matters. 151. Medical officer of health may delegate functions. A medical officer of health may delegate to any person of the exercise or performance of any or all of his or her powers or functions under this Act in relation to the health district concerned. The medical officer of health may delegate the exercise of or performance of any power or function to a person only if satisfied that he or she is suitably qualified or trained to exercise or perform it. A delegation must be written and must contain a reference to this section and state the full name of the delegate and state the name of the health district. Also DHB. Next. Subpart 5, appeals. Now, how far down is that? Down here. Holy. Goodbye. Okay. Okay, subpart 5, appeals. Effect of decisions when appeal may be filed or while appeal is pending. 152. Light, please. Okay, I'm gonna grab some more water. Oh. All right. Okay. Yeah, here we go. Back to it. So that doesn't pick up. Interesting. um, that open and that open. One. One, two. Okay, it's good. One. Cool. Back to it. Suspension of certain decisions by a licensing committee or licensing authority to grant license or manager's certificate. Okay. This section applies to every decision to grant an application for a license or manager's certificate if an objection to the application has been duly filed and has not been withdrawn, or a report has been submitted by the police or an inspector or an employee, volunteer, or no, didn't want to do that. Over there. An employee, volunteer, or contractor of the Foreign Emergency New Zealand, or a medical officer of health recommending that the application be refused. Okay. And we're up to 2. A decision to which this section applies has no effect during the period allowed for filing an appeal against the decision, and if an appeal is filed against the decision, also has no effect while the appeal is pending. Where an appeal relates to a decision to which this section applies but is limited to one or more conditions that form part of the decision, the appellate tribunal may, subject to any conditions the appellate tribunal thinks fit to appellate to impose order that the decision is to have effect while the appeal is pending. An order under subsection 3 may only be made if the appellate tribunal is satisfied that all parties to the appeal agree to the order, including any conditions imposed by the tribunal. No appeal may be brought against a refusal to make an order under subsection 3. In this section and in section 153, appellate tribunal means the licensing authority or the court that hears and determines an appeal under this act. No, that's not what I meant to do. Okay, we've done that one. Next. 153. Effects of appeal against other decisions. This section applies to every decision that is not a decision to which section 152 applies. A decision to which this section applies has effect during the period allowed for filing an appeal against the decision, and if an appeal is filed against the decision, also has effect while the appeal is pending. However, the appellate tribunal may, on its own initiative or on an application, or an application made for the purpose that order that a decision to which this section applies is not to have effect while the appeal is pending, despite subsection 3, which an appellate tribunal may not make an order under that subsection in relation to a decision made under section 286, way later, which relates to the suspension of licenses for non-compliance with public health or fire precaution requirements. Whether an appellate tribunal makes an order to under subsection 3 in relation to a decision to refuse new or to suspend or to cancel any license or manager's certificate under the license or manager's certificate must, if the appeal is not finally determined on or before the expiry of the license or certificate, must be deemed to be extended until the final determination of the appeal. Next. Appeals to licensing authority. Who may appeal? Any party to any proceedings before a licensing committee who is dissatisfied with the decision or any part of the decision may appeal to the licensing authority against the decision or any part of the decision. Procedure for commencing appeal. An appeal under section 154 must be made by the appellant, giving notice of appeal to the licensing authority within 10 working days after the date on which notice of the decision is given to that party. Yeah. We're up to. Despite subsection 1. on the application of any person having a right of appeal under this section, the licensing authority may extend the time for making an appeal to any time it sees fit if the licensing authority is of the opinion that there was a reasonable cause for the failure or inability of the appellant to appellant. I still get that mixed up. To give notice within the prescribed time. The notice of appeal must be in writing and specify the grounds of appeal in sufficient detail to fully inform the licensing authority and other parties of the issues in the appeal, and be sent to the secretary of the licensing authority and be accompanied by the prescribed fee. The police, inspectors, and medical officers of health are not required to pay the prescribed fee, either before or immediately after the notice of appeal is sent to the secretary of the licensing authority. A copy of the notice must be served on each of the other parties to the proceedings before the licensing committee, and a copy left with the secretary of that licensing committee. Lots and lots of copies, I guess. As soon as possible, the receipt by the secretary of the licensing committee of a copy of a notice of appeal, the secretary must send to the secretary of the licensing authority. Any application and supporting documents filed with the licensing committee, and any written submissions, statements, reports, and other papers relating to the decision made appealed against. A copy of any notes or other record made by the licensing committee of the evidence given at the hearing, any exhibits in the custody of the licensing committee, a copy of the decision appealed against. Next. Okay. (156) Adjournment if notice of appeal not given. If licensing authority is not satisfied that a copy of the notice of appeal has been given to each of the other parties to the proceedings before the licensing committee, the licensing authority may adjourn the proceedings and give directions for the service of copies of the notice as it thinks fit. Every person on whom a copy of the notice of appeal is served is entitled to attend as a party to the proceedings before the licensing authority. And 157. Okay. Appeals by way of rehearing. Every appeal is by way of rehearing. However, where any question of fact is involved is something in any appeal, the evidence taken before the licensing committee bearing on the question must, subject to any special order, be brought before the licensing authority as follows. As to any evidence given orally, by the production of a copy of the chairperson of the licensing committee's note or of a written statement read by the witness while under oath, or of such other materials as the licensing committee may consider expedient. As to any evidence taken by affidavit, and as to any exhibits by the production of the affidavits and such of the exhibits as may have been forwarded to the licensing authority by the licensing committee, and by the production by the parties to the appeal of such exhibits as are in their custody. Despite subsection 2, the licensing authority may, in its discretion, rehear the whole or any part of the evidence, and must rehear the evidence of any witness if the licensing authority has reason to believe that any note of the evidence of that witness made by the chairperson of the licensing committee is or may be incomplete in any material particular. The licensing authority has full discretionary power to hear and receive further evidence on questions of fact, either by oral evidence or by affidavit. The secretary of the licensing authority must also return to the secretary of the licensing committee any application, papers, and exhibits forwarded by the secretary of the licensing committee under section 1556. 158. Determination of appeal. On hearing an appeal, the licensing authority may confirm, modify, or reverse the decision under appeal. Appeals to High Court. Any party may appeal to the High Court against a decision of the licensing authority if the proceedings concerned commenced in the licensing authority, or a licensing committee referred the proceedings concerned to the licensing authority for a decision. Yeah, okay. 160. Procedure for commencing appeal. Under section 159, an appeal under section 159 must be made by the appellant giving notice of the appeal to the High Court within 10 working days after the date on which notice of the decision is given to the applicant, licensee, or manager. Subject to sections 152, 153, and 161 to 166, and subsection 3, every appeal under this section must be dealt with in accordance to the rules of court. Either before or immediately after the filing of the notice of appeal, the appellant must leave a copy with the secretary of the licensing authority. As soon as possible after the receipt by the secretary of the licensing authority of a copy of a notice of appeal, the secretary must send to the office of the High Court in which the appeal has been filed any application and supporting documents filed with the licensing authority, and any written submissions, statements, reports, and other papers relating to the decision appealed against, a copy of the notes made by the chairperson of the evidence given at the hearing, any exhibits in the custody of the licensing authority, and a copy of the decision appealed against. 161. Appeals. Every appeal is by way of... Didn't I just read this? I read this like not that long ago. Am I going crazy? Oh, I probably read it up here. Now it's down here. But specifically to High Court. Ugh. Okay. Every appeal is by way of rehearing. However, where any question of fact is involved in any appeal, the evidence taken before the licensing authority bearing the question must be subject to any special order but be brought before the High Court as follows. As to any evidence given orally or by the production of a copy of the chairperson's note or of this written statement be read by the witness while under oath, or of such other materials as the High Court may consider expedient. Okay. As to any evidence taken by affidavit, and as to any exhibits by the production of the affidavits and such of the exhibits as may have been forwarded to the court by the licensing authority, and by the production of by the parties to appeal of such exhibits as are in their custody. Despite subject to Section 2, the High Court may, in its discretion, rehear or the whole or any part of the evidence, and must rehear the evidence of any witness if the court has reason to believe that at any note of the evidence of that witness made by the chairperson of the licensing authority is or may be incomplete in any material particular. The court has full discretionary power to hear and receive further evidence on questions of fact, either by oral evidence or by affidavit. If the appellant does not appear at the time appointed for the hearing the appeal must be dismissed. If the appellant does not prosecute the appeal with the due diligence, any other party to the appeal may apply to the High Court for the dismissal of the appeal. On hearing the appeal, the High Court may confirm, modify, or reverse the decision appealed against, and the decision of the court is final and binding on all parties. The registrar of the High Court must transmit to the Secretary of the Licensing Authority a memorandum of the decision of the court and the decision in relation to the proceedings appealed against must be treated as if it had been given by the authority. The registrar must also return to the Secretary of the Licensing Authority and any application, papers, and exhibits forwarded by the Secretary pursuant to Section 164. Next, 162. Appeal against decision of licensing authority on question of law. Subject to subsection 3. Where any party to any proceedings before the licensing authority, whether the proceedings commenced in a licensing committee or the licensing authority, is dissatisfied with any determination of the licensing authority in the proceedings as being erroneous in point of law, that party may appeal to the High Court on the question of law concerned. subject to subsections 152, 153, 161, and 163 to 166. Every appeal under the section must be dealt with in accordance with rules of court. This section does not apply to a decision by the licensing authority to cancel a license under Section 289 or to cancel a manager's certificate under Section 290. Okay, next. Right to appear and be heard on appeals. Is this still in High Court? Yes. Okay. Okay. Any party to the proceedings before the licensing authority who wishes to appear and be heard on the hearing of the appeal must, within 7 working days after the date of the service on that party, of a copy of the notice of the appeal, lodge with the registrar of the High Court a notice of that party's intention to appear and be heard. Any party who gives a notice of intention to appear and be heard, and the appellant are parties to the appeal and are entitled to be served with every document later filed or lodged with the registrar relating to the appeal, and to receive a notice of the dates set down for the hearing of the appeal. 164. Orders relating to the determination of appeals. Subject to subsections 2 and 3, the High Court may, of its own motion or on the application of any party or to the appeal, make all or any of the following orders. An order directing the licensing authority to lodge with the registrar of the High Court and any document or written material or any exhibit in the possession or custody of the licensing authority. An order directing the licensing authority to lodge with the registrar of a report recording in respect to of any manner or issue of that the court specifies, any of the findings of fact of the licensing authority that are not set out or fully set out in its determination. An order directing the licensing authority to lodge with the registrar a report setting out in respect of any matter or issue that the court specifies, any reasons or considerations of the licensing authority to which the licensing authority had regard that are not set out in its determination. Okay. Did I just read that one or that one? I just read that one. An application under subsection 1 must, in case of the appellant, be made within 20 working days after the date of the lodging of the notice of appeal, or in the case of any matter other than of any other party to the appeal, within 20 working days after the date of the service on that party of a copy of the notice of appeal. The High Court may make an order under subsection 1 only if it is satisfied that a proper determination of the point of law in issue so requires, and the order may be made subject to conditions as the High Court thinks fit. 165. Appeal on additional question of law. Any party other than the appellant to an appeal under section 162 who wishes to contend at the hearing of the appeal that the determination appealed against is erroneous in point of law in relation to a question of law not set out in the notice of appeal may, within 20 working days after the date of the service on the party of a copy of the notice of appeal, lodge a notice to that effect with the Registrar of the High Court, with any necessary modifications to sections 162, 164, and 166 apply to a notice lodged under subsection 1 as if it were a notice of appeal. 166. Extension of time. The High Court or a judge of the High Court may, or on the application of the appellant or intending appellant or any other party, extend any time prescribed or allowed but under any of the provisions under sections 159 to 165 for the lodging of any notice, application, or other document. I've read 60 parts now, I think. Today. No review. 167. No review until right of appeal exercised. No person. No person who has a right of appeal against any decision of the licensing authority or of a licensing committee is entitled to do any of the following unless and until that party exercises that right of appeal and the appeal is finally determined, to make an application for review of that decision under the Judicial Review Procedure Act 2016, or to institute proceedings seeking any writ or order of in the nature of mandamus. I don't know what that means. Prohibition or certiorari. I need to get a lawyer to tell me what those mean. Or a declaration or injunction in respect of that decision. Appeals to Court of Appeal. 168. Further appeal to Court of Appeal. Any party who to an appeal under section 162. Oh my god, this is a lot. Who is dissatisfied with the determination of the High Court on any point of law that may, with leave of the High Court, or if that leave is declined, with special leave of the High Court, appeal to the Court of Appeal against the determination. Yeah. A party desiring to appeal to the Court of Appeal under this section must, within 15 working days after the determination of the High Court, or within such further time as the court may allow, give notice of the application for leave to appeal in such manner as may be directed by rules of court, and the High Court may grant leave accordingly if, in the opinion of that court, the question of law involved in the appeal is one that, by reason of its general or public importance, or for any other reason, ought to be submitted up to the Court of Appeal for decision. Where the High Court refuses to leave to any party to appeal, the Court of Appeal under this section, that party may, within 15 working days after the refusal of the High Court, or within such further time as the Court of Appeal may allow, apply to the Court of Appeal in such manner that as may be directed by rules of court, for special leave to appeal to that court, and the Court of Appeal may grant leave accordingly, and if in the opinion of that court the question of law involved in the appeal is one that, by reason of its general or public importance, or for any other reason, ought to be submitted to the Court of Appeal for decision. On any appeal to the Court of Appeal under this section, the Court of Appeal has the power to adjudicate on the proceedings that the High Court had, and judgment is to be entered in the High Court, and execution and other consequences and proceedings follow as if the decision of the Court of Appeal had been given in the High Court. The decision of the Court of Appeal on any application to that court for leave to appeal is final. Next. Subpart 6. How long has it been? 2 hours. Right, we can make a start on it. Licensing bodies. Alcohol Regulatory and Licensing Authority. Alcohol Regulatory and Licensing Authority, Section 169. This section continues in existence and authority to be called the Alcohol Regulatory and Licensing Authority. The Licensing Authority is the body established in Section 85(1) of the former Licensing Act, and immediately before the commencement of this section, called the Liquor Licensing Authority. 170. Functions of the Licensing Authority. The Licensing Authority's functions are to consider and determine the following matters when referred to it by the licensing committees: applications for licenses, applications by licensees for the renewal or variation of licenses, applications for manager's certificates, applications for the renewal of manager's certificates, and to consider and determine the appeals from decisions of licensing committees, and to consider and determine appeals against the elements of draft local alcohol policies, and to consider and determine applications by inspectors and constables for the variation, suspension, or cancellation of licenses and managers' certificates, and any other functions conferred on it by or under this Act or any other enactment. 171. Powers of Licensing Authority. The Licensing Authority has all powers conferred on it by or under this Act or any other enactment, and all other powers reasonably necessary to enable it to perform its functions satisfactorily. Licensing Authority may issue practice directions. For the purpose of ensuring that the application and administration of this Act is consistent, the Licensing Authority may, from time to time, issue, for the guidance of licensing committees, any directions, notes, guidelines, or suggestions not being inconsistent with this Act that the Licensing Authority considers necessary or desirable. 173. Licensing Authority may give directions where licensing committee in doubt. Okay. A person who is in doubt as to the appropriate licensing committee to apply to may apply to the Licensing Authority for directions, and the authority's directions have effect according to their tenor and override the requirements of this Act as to which licensing committee apply to. 174. Licensing Authority may refer to matters for investigation. The Licensing Authority may appoint one of its members or any or other qualified person other than an inspector to investigate and report to the authority on any matters it refers to as the person to that person for the purpose of the proper exercise of its powers or functions under this Act. A person who has custody or possession of any books, papers, accounts, or other documents relevant to any matter to be investigated under this section commits an offence if he or she fails or refuses to allow the person conducting the investigation to have access to the documents or obstructs that person in the conduct of the investigation. A person who commits an offence is against subsection 2 is liable on conviction to a fine of not more than $2,000. 175. Licensing authority may refer matters to licensing committees. The licensing authority may ask a licensing committee to inquire into and report to the authority on any matter within the scope of the authority's functions. When reporting to the licensing committee must send to the licensing authority notes of any evidence taken before it in its inquiry, together with any written submissions made to it, and may make any recommendations on the matter it thinks fit. On receiving the licensing committee's report, the licensing authority may make any decision or order as if it had heard the proceedings itself, or may hear further submissions or evidence on the matter before making any decision or order. 176. Licensing authority may give statements to licensing committees. The licensing authority may give licensing committees statements setting out to its views on the general admission of this Act or the policies to be followed in the administration of this Act. Yeah. Okay. Administration of this Act or any provisions of it, or any information obtained by the authority from any inquiry held by it or from any other source. A statement must not relate to a matter that may be a ground for an appeal against a decision of a licensing committee. In performing its functions under this Act, a licensing committee must observe every statement issued under this section. Meetings of licensing authority. Meetings of the licensing authority may be held at any time and place, or it or its chairperson decides. At all meetings of the licensing authority, 2 members are a quorum. Don't know what that means. Quorum. If present at a meeting of the licensing authority, its chairperson has a deliberative vote, and in the case of an equality of votes, also has a casting vote. A deputy chairperson of the licensing authority does not have a casting vote. The decision of the licensing authority on any matter is determined by a majority of the valid votes recorded on it. 178. Annual report. Within 6 months after the end of its financial year, the licensing authority must prepare and send to the minister a report on the authority's proceedings and operations during the year, and on the working of this Act and the desirability of or otherwise of amending it. The minister must lay a copy of the report before the House of Representatives in 20 sitting days after the day on which he or she receives it. 179. Membership of licensing authority. The licensing authority comprises the following members appointed by the Governor-General on the recommendation of the minister, up to 3 district court judges, any number of other members. No person is employed in the service of Her Majesty. That's outdated, so it's now His Majesty, technically. Amended on, it's in 2020, so needs to be updated, I guess. Or not, you could just leave it as Her Majesty. For the purposes of the Public Service Act 2020, by virtue of appointment to the licensing authority. 179A. If a appointment of temporary acting chairperson, deputy chairperson, or member. If the chairperson, a deputy chairperson, or a member of the licensing authority becomes incapable of acting by reason of illness, absence, or other sufficient cause, something happens. And that thing that happens, or if the chairperson, a deputy chairperson, or a member of the licensing authority considers it not proper to, or not desirable to, that he or she should adjudicate on a specified matter, now something happens. The Governor-General, on the recommendation of the minister, may appoint a suitable person as the acting chairperson and an acting deputy chairperson or an acting member for the period or purpose stated in the appointment. No person may be appointed as the acting chairperson, an acting deputy chairperson, or an acting member unless he or she is eligible for appointment to the relevant position. An acting chairperson, acting deputy chairperson, or acting member is, while acting in the position, is to be treated as the chairperson, deputy chairperson, or a member in the licensing authority. No appointment of an acting chairperson, acting deputy chairperson, or acting member, no act done by an acting chairperson, acting deputy chairperson, or acting member, and no act done by the licensing authority may be questioned in any proceedings on the ground that the occasion for the appointment had not arisen or had ceased. 179B. Orderly and efficient operation. The chairperson of the licensing authority is responsible for making any arrangements that are practicable to ensure that he or she and each member perform their functions in an orderly and efficient manner and in a way that achieves the purposes of this act. Okay. 180. Chairperson and deputy chairperson. As the office becomes vacant, a member of the licensing authority who is a district court judge must be appointed chairperson of the authority. Every other member of the licensing authority who is a district court judge must be appointed a deputy chairperson of the authority. Appointments must be made by the Governor-General on the recommendation of the minister and can be made when the member is appointed a member or later if there are two deputy chairpersons and both are present, the deputy chairperson who was first appointed to the licensing authority serves as an acting chairperson in the chairperson's absence. A deputy chairperson who serving as chairperson in the chairperson's in the chairperson's absence has all the powers of the chairperson. No acts done by a deputy chairperson in oh my god, it's going to be so many chairpersons. It's going to be a tongue twister. Serving as acting chairperson in the chairperson's absence, no acts done by the licensing authority, while a deputy chairperson is so serving can, in any proceedings, be questioned on the ground that the occasion for his or her so serving had not arisen or had ceased. Term of office of members. Do I stop here? How long's it been? 2 hours 16. I think I might stop here. No, I think that's probably my longest live stream, out of these 3 that have been. Yeah, it is. And yeah, out of these 3, not the Jolsman ones. And who knows when part 4 will be. Will part 4 even exist? Yeah. Okay, fuck it. I'll read this one more section. Maybe I go to 2 hours and 20 minutes. Term of office of members. A member of the licensing authority holds office for a term stated when the member is appointed for up to 5 years and may be reappointed for further terms of up to 5 years. A member continues in office despite expiry of his or her term of office until the member is reappointed, or the member's successor is appointed, or the member is notified that a replacement will not be appointed, or the member vacates or is removed from office. A member who continues in office for any period under subsection 2, unless he or she was removed from office, may act as a member during that period for the purpose of completing any proceedings partly or wholly heard by the licensing authority before the expiry of his or her term of office, and hearing any other proceedings. A member who has resigned or whose successor is appointed or who will not be replaced unless he or she was removed from office may continue in office for the purpose of completing any proceedings that are partly or wholly heard. Okay, this one's short, so I'll keep going. Resignation or removal from office. A member of the licensing authority may resign from office at any time by written notice to the minister. The Governor-General may at any time, on the recommendation of the minister, remove a member of the licensing authority from office for inability to perform the functions of the office, bankruptcy, neglect of duty, or misconduct proved on the Governor-General's satisfaction. This section overrides Section 181, Part 1. Subpart 1. Subsection, whatever. Fees and allowances. Or do I go to 2.5 hours? A member of the licensing authority who is not a district court judge and is entitled to receive a remuneration not within subsection 2 or for services as a member at a rate and of a kind determined by the minister in accordance with the fees framework. Every member of the licensing authority is entitled in accordance with the fees framework to be reimbursed for actual and reasonable travelling and other expenses incurred in carrying out his or her office as a member. For the purposes of this section, fees framework means the framework determined by the government from time to time for the classification and remuneration of statutory and other bodies in which the Crown has an interest. Officers of Licensing Authority. There must be appointed under the Public Service Act 2020 a secretary of the licensing authority and all other employees necessary for it to carry out its functions efficiently. That was all right. Yeah. Now there's lots of short sections. Professional assistance 185. With the minister's authority, the licensing authority may engage under a contract for services any professional, technical, or other assistance it thinks necessary to enable it to carry out its functions. 186. District licensing committees. Territorial authorities to appoint district licensing committees. Each territorial authority must appoint one or more licensing committees as, in its opinion, are required to deal with licensing matters for this district. Okay, where are we? 186 is here. Are we more than halfway yet? No. Not more than halfway yet. So just read that. 2 hours 23. God damn it. Okay. Functions of licensing committees. A licensing committee's functions are to consider and determine applications for licenses and managers' certificates, and to consider and determine applications for renewal of licenses and managers' certificates, and to consider and determine applications for temporary authority to carry on the sale and supply of alcohol in accordance with Section 136, and to consider and determine applications for the variation, suspension, or cancellation of special licenses, and to consider and determine for the variation of licenses other than special licenses unless the application is brought under Section 280, and with the leave of the chairperson for the licensing authority to refer applications to the licensing authority and to conduct inquiries and to make reports as may be required of it by the licensing authority under Section 175, and any other functions conferred on licensing committees by or under this Act or any other enactment. And here we go. Continuing. Because why not? It's 5:38. Mm. 188. Powers of licensing committees. A licensing committee has all the powers or conferred on it by or under this act or any other act, and all powers as may be reasonably necessary to enable it to carry out its functions. Cool. 189. Oh, that's a big one. Composition of licensing committees. Each licensing committee consists of 3 members appointed by the territorial authority for that territorial authority's district. Mm-hmm. One moment. District, yeah, I got that. A territorial authority must appoint 1 member as the chairperson of, and that person must be a member of that territorial authority or a commissioner appointed to the licensing committee. A territorial authority may appoint a member of the territorial authority to be deputy chairperson and act in place of the chairperson if the chairperson is unable to act because of illness or absence from New Zealand or for other sufficient reason. While acting in place of the chairperson, the deputy chairperson is a member of the committee and has all the powers of the and duties of the chairperson. No act done by the deputy chairperson serving as acting chairperson in the chairperson's absence, and no acts done by the committee while the deputy chairperson is so serving, and in any proceedings be questioned be on the ground that the occasion for his or her so serving has not arisen or has been ceased or had ceased. No act done by, I just read that. The other 2 members of each licensing committee must be appointed from the territorial authority list maintained under Section 192. For the purposes of subsection 2, a member of a territorial authority means an elected member of a territorial authority, and in relation to the Auckland Council, includes a member of a local board established under Section 10 of that Act. Yeah. Something Auckland Council. 190. Meetings of licensing committees. Meetings of a licensing committee may be held at any time and place or its chairperson decides. At a meeting where 3 members are present, the decision of a licensing committee on any matter is determined that by a majority of the valid votes recorded on it. Quorum. Heard this word earlier. Except as provided in subsection 2, at any meeting of a licensing committee, the quorum necessary is 3 members. At a meeting to consider and determine an application of a kind listed in subsection 3, where no objection has been filed at and no matters of opposition have been raised under section 103, 129, or 141, the quorum necessary is one member who must be the chairperson. The applications are an application for a license, application for a manager's certificate, and an application for renewal of a license or manager's certificate. Next. 192. I'm still going, Jesus. Territorial authority to establish and maintain a list of licensing committees members. A territorial authority must either establish, maintain, and publish its own list of persons approved to be members of the territorial authority's licensing committees or committees, or together with one or more other territorial authorities, establish, maintain, and publish a combined list of persons jointly approved by those authorities to be members of the territorial authority's licensing committees. A territorial authority must not approve a person to be included on the list unless that person has an experience relevant to alcohol licensing matters. A person may be approved for inclusion on the list for a period of up to 5 years and may be approved for any one or more further periods of up to 5 years. A person may be approved for inclusion on the list for a period of up to 5 years and may be approved for any one or more. I just read that. The name of a person must be removed from the list when 5 years have elapsed since the territorial authority approved the person's name on the list unless the approval is renewed under subsection 3, or if the person resigns or is removed under section 194. Person if the person resigns or is removed under section 194, a person must not be included on the list if the territorial authority believes that person has, directly or by virtue of his or her relationship with another person, such an involvement or appearance of involvement with the alcohol industry that he or she could not perform his or her duties without actual bias or the appearance of bias, or the person is a constable, a medical officer of health, an inspector, or an employee of the territorial authority. 193. Appointment of commissioners. The chief executive of a territorial authority may, on the recommendation of the territorial authority, appoint a commissioner or commissioners to any of the territorial authority's licensing committees, and any person so appointed has all the functions, powers, and duties of the chairperson of the licensing committee. The chief executive may only appoint a person or as a commissioner if the person is of good standing in the community and has the necessary knowledge, skill, and experience relating to matters that are likely to come before the committee. A person must not be appointed as a commissioner if the territorial authority believes that the person has, directly or by virtue of his or her relationship with another person, such an involvement or appearance of involvement with the alcohol industry that he or she could not perform his or her duties without actual bias or the appearance of bias, or the person is a constable, medical officer of health, an inspector, or an employee of the territorial authority. A commissioner appointed under this section holds office for a term stated when the commissioner is appointed of up to 5 years and may be reappointed for one or more further periods of up to 5 years. Registration and renewal. A member of a licensing committee or a commissioner appointed to a licensing committee may resign from office at any time by written notice to the relevant territorial authority. A chairperson of a licensing committee ceases to be a chairperson if he or she ceases to be a member of the licensing committee's territorial authority. The territorial authority may at any time remove a member of a licensing committee or a commissioner appointed to a licensing committee for inability to perform the functions of office, bankruptcy, neglect of duty, or misconduct proved to by the territorial authority's satisfaction. Fees and allowances for the members. For members. Yeah. A member of a licensing committee is entitled to receive remuneration for not within subsection 2 for services as a member at a rate and of a kind determined by the minister in accordance with something by the minute with the fees framework. There we go. A member of the licensing committee is entitled in accordance with the fees framework to be reimbursed for actual and reasonable travelling and other expenses included in carrying out his or her office as a member. For the purposes of this section, fees framework means the framework determined by the government from time to time for the classification and remuneration of statutory and other bodies in which the Crown has interest. A commissioner is to be treated as a member of a licensing committee for the purposes of this section. 196. One line, great. Secretary of Licensing Committees. For the purposes of this Act, the Chief Executive of the Territorial Authority is the Secretary of Licensing Committees. Cool. 197. Licensing Inspectors. For the purposes of this Act, the Chief Executive of each Territorial Authority must appoint one or more licensing inspectors for its district. Inspectors must monitor licensees' compliance with this Act. Inspectors have all the other functions, powers, and duties conferred on them by or under this Act. Inspectors must act independently when exercising and performing their functions, duties, and powers, and each territorial authority must take steps to ensure that its inspector or inspectors are able to act independently. If more than one inspector is appointed by a territorial authority, then the territorial authority must appoint one of the inspectors to be its chief licensing inspector. And the function of a chief licensing inspector is to foster consistency in enforcement of this Act. 198. And that's a big one. I'll probably finish there. Okay, that's literally enough. I cannot be bothered continuing. I've read 90-something sections today. 106 to 198 is 94? 93, 92. 92 sections, and that's 2 hours and 40 minutes, which is very long. So who knows, there might be a part 4. Well, there will be, probably. But I'm leaving it there for now. Goodbye. I don't know. That's it for today. End stream. Yes. Goodbye.